Alex here with a legal nuts and bolts video on disqualification of counsel or disqualification of an attorney or lawyer. It's basically what I'm talking about. Unlike my last video, disqualification of judge, I'm not going to go really far into what it takes to disqualify an attorney from representing your opponent. I should have got into that. What I'm talking about here is basically I just want people to know that this exists, that it's possible to do this. You can disqualify your ex or your opponent, whoever they are, from using the lawyer that they're currently using in your case. I didn't know that this was possible. It never came up in my case at all. But once my case was closed and done with and I started to help other people, the issue did start to come up. I started to look into it and I was quite curious as to how it worked. I never heard of this actually being a thing. And basically that's why I'm doing this video, just to share that knowledge with you guys. So my understanding, and this is a really big picture abstract explanation. You have to look into the specifics of your own state before you just take this and run with it. My understanding is that at least our Supreme Court has recognized that it is unfair for your opponent to have an attorney that you personally met and established an attorney-client relationship with. Because that attorney, whether it doesn't matter if it has nothing to do with, like, let's say right now you're in a divorce case. It doesn't matter if that lawyer was your lawyer in a car accident case. According to the Supreme Court, from what I've seen, that lawyer had an attorney-client relationship with you, and it's just, what it comes down to is it's unfair because they know you so well that they can use that against you in the new case. It just comes down to fairness, really. I can't explain it any other way. If anyone has done this in their own personal case and they got, knee deep in the case law or the statutes and they figured out how it worked and they were successful, or even if they weren't successful, post in the comments below and let us know. I really wish I could go more into it than that. I do know that the case law, at least in Nevada, is extensive because it constantly came up in really big multi-million-dollar cases like personal injury, pain and suffering, insurance malpractice, or sorry, medical malpractice, insurance bad faith. And these multi-million-dollar cases, it seems like people tried to disqualify their opponent's attorney a lot. And so the line was constantly shifting as to what constituted too much of a relationship. At one point, did your opponent's lawyer know you too well? At what point did they know too many of your secrets, that to the point that it was just so unfair that it just couldn't be allowed? That your opponent's just going to have to hire another lawyer because it's just completely gaming the system. So I do know that, I'll mention a few things that I know. I do know that there is some grounds to disqualify an opponent's attorney if you didn't meet with them, but they joined a firm that represented you, or I don't know, somehow a lawyer connecting to a firm, somehow you can build some kind of basis to disqualify them on that basis. I wish I could tell you more. I just didn't look that far into it. I do know that that's something to look into. I guess apparently this issue would come up. Lawyers would change firms, and then somebody would be fighting that firm and be concerned that even though they weren't going up against an attorney who personally had worked with them in the past, an attorney that they had met with worked with them in the past, was now employed at that firm. I know that that was in the case law. I didn't read enough of it to really give people specifics on that. And I do know that merely sending them emails or calling them on the phone, maybe even meeting with them for that first face-to-face consultation, I do know that that does not appear to be enough. That it seems to take a little bit more than that. Whether it takes signing a retainer agreement or paying them money or having them had done a paper pleading or orally argued for you, I don't know what exactly it is that triggers it. I'm just going to go right back to what I said in the beginning of the video. I really want you guys to just know that this is actually a thing you can do, that if it's relevant in your case, take a look into it. And if it's happened to you in the past, or you have successfully disqualified your opponent's attorney in the past, post in the comments below. It'll probably be really helpful to a lot of us here who may be curious about it. So with that, I'm going to go ahead and end this video.